Obviously, one of the big things that got you going as a academic was your history, and you're looking at witchcraft and in England in the 16th century in Essex and around there. So, and obviously this flushes out quite a few of the things that we've been talking about. This kind of, because I suppose we associate witchcraft with pre-modernity and a whole kind of beliefs that we're not supposed to have anymore. But it seems as though one of the interesting things that you discovered increasingly is that perhaps we can learn a lot about ourselves by looking at what was going on in these witchcraft trials and stuff like this. Do you want to just give us the setting for where you went with your witchcraft and what you actually found?
Well, I'll very rudely do that as a second answer, because there was one part of the legal system which is terribly
right.
to, and I omitted. In most legal systems, you have law, which is very punitive, and that is it. Law has nothing to do with justice.
Right. This goes back to the question we were asking before then, yeah?
Fairness.
Yeah.
Yes, going back to
equity and that stuff, yeah.
Yes, because basically the very important feature of the English legal system was that it was divided into both law and equity. I think, as you say, I may have talked about this, so I'll leave it at that. Did I talk about that earlier?
I don't think you did. I think it was just something I read.
Okay, well, basically, the English said you can have a law, but law is very firm, and it doesn't deal with the nuances of everyday life. And it doesn't protect lots of rather vulnerable and weak people, because it often sides with the wealthy and the powerful. You need a parallel system to protect the weak, and also to get to those difficult cases where the law says one thing, but everyone knows that it's not fair. So the notion of fairness, I mean, I may have mentioned this in relation to the games, the rules of a game, whereby you can play by the rules of a game, but you can cheat by playing against the spirit of it. So, for instance, there's no rule in football that you can't dance about in front of a player and start making him laugh. But it's not fair to make a player laugh in the middle of his football strategies. Now, in England, they developed from very early on, and certainly by the 12th, 13th century, a branch called equity, which means fairness, which was presided over by the Lord Chancellor, the most powerful law official in England. And it had a different procedure. It didn't work by having courts with juries and so on. It wasn't done in Latin, done in English. And you would put in a petition to the Lord Chancellor saying, I know there's no law on my side in this, but I feel that I've been treated unfairly. And women could do this, incredibly important for the legal position of women, chancery. Children could do it. People who have no money could do it. The Court of Requests was particularly for the poor, because often there were no fees involved. And you would just go. I mean, the great account of the last days of equity is in Charles Dickens's novel. Is it Bleak House?
Bleak House. Chancery runs all the way through it, yeah.
Yeah, Bleak House. If you want to read about the bad side of equity, or at least where it degenerated. But basically, for centuries, it protected. To give you an example, if you were a landowner, a small villager who had a property and you've been living there for 20 years, and then someone came and said, I want your property, show me your deeds, and you'd lost them. Now, everyone knew that it was your house and you'd been there for 20 years, and you were old, and you just mislaid them. You could go to the Lord Chancellor and say, I'm sorry, I'm old, I've lost the deeds. Everyone, you can ask my neighbours, they all know that I own this house. And the Lord Chancellor would protect you. And there were many, many cases like that, you know, husbands behaving unfairly to wives, all this sort of stuff, parents with children. And so this branch, which was just as big and to do with all this, gave the English, then helped to give the English the notion of fairness and fair play. The fact that we had an unarmed police force, which is extraordinary. There's nowhere else in the world which has had that for century after century after century. Ordinary villagers would become the policemen, the constables of the village. So in France, you had an armed gendarmerie, but not here. And so we had this notion that the law is on your side, that you can go to a policeman and you know, they should listen to you and be supportive, and you have no fear of sudden arrest and death. And if you have a problem, and think of what this produces for the underpinning of a capitalist society. This is why Adam Smith's second great work as part of The Wealth of Nations is called Essays on Jurisprudence. They were Adam Smith's essays on law and justice, because he knew that you cannot have a modern capitalist system working unless it's underpinned by the civil law, which protects individuals, that you can take cases to civil courts. And so the underpinning of the freedom of the individual, the safety of the individual, the feeling that you live in a fair and just society, and that your property and rights will be protected, all those stem from our legal system. And so when we talk about the rule of law, Margaret Thatcher was a great one for talking about it. She didn't understand the first things about what it meant. She thought it meant, you know, having strong police force. But it means the ubiquity, that every part of everyone's life all the time is protected by due process of law, that you cannot be imprisoned, you cannot be executed without due process of law. So it's about the process of law.